October 12, 6:02 a.m. Recording Political Law 2024, Cruise, Chapter 7, Delegation of Powers. Sharing screen. Okay. Corollary to the doctrine of separation of powers is the principle of non-delegation of powers. The rule is potestas delegata non delegari potest. What has been delegated cannot be delegated. It is based upon the ethical principle that such delegated power constitutes not only a right, but a duty to be performed by the delegate through the instrumentality of his own judgment and not through the intervening mind of another. A further delegation of such power, unless permitted by the sovereign power, would constitute a negation of this duty in violation of the trust reposed in the delegate mandated to discharge it directly. The principle of non-delegation of powers is applicable to all the three major powers of the government, but is especially important in the case of legislative power because of the many instances when its delegation is permitted. The occasions are rare when executive or judicial powers are exercised outside the departments to which they legally pertain. In the case of legislative power, however, such instances have become more and more frequent, if not necessary. This has led to the observation that the delegation of legislative power has become the rule and it's not delegation, non-delegation the exception. The reason is the increasing complexity of the task of government and the growing inability of the legislature to cope directly with the many problems demanding its attention. The growth of society has ramified its activities and created peculiar and sophisticated problems that the legislature cannot be expected reasonably to comprehend. Specialization, even in legislation, has become necessary. To many of the problems attendant upon present day undertakings, the legislature may not have the competence, let alone the interest and the time to provide the required direct and efficacious, not to say specific solutions. One such problem, to take an example, is the regulation of common carriers. This task requires the determination of such intricate matters as the routes to be serviced by such carriers, the number of them to be allowed in each route, the conveniences they should offer the passengers, the fare they may charge, the type of vehicles they should use, and other myriad detail that the legislature may not have the time, expertise, and interest to prescribe. Given these shortcomings, the Congress may then create an administrative body like the Land Transportation Franchising and Regulatory Board and empower it to promulgate the needed rules and regulations subject only to certain statutory limitations or broad policies predetermined by the legislature itself. Such a device, as applied to 100 other similar cases, can relieve the Congress of many problems that are better left to be solved by more capable entities and at the same time enable to tackle the more serious difficulties of the country requiring its direct and immediate attention. Permissible delegation. Delegation of legislative power is permitted in the following cases: delegation of tariff powers to the president, delegation of emergency powers to the president, delegation to the people at large, delegation to local governments, and delegation to administrative bodies. It should be noted that in Belgica versus Executive Secretary, the Supreme Court annulled a provision in a general appropriations law conferring post enactment identification authority to individual legislatures because it violates the principle of non delegability, since said legislators are effectively allowed to individually exercise the power of appropriation, which is lodged in Congress. Tariff powers. Section 28, paragraph 2. The Congress may, by law, authorize the President to fix within specified limits and subject to such limitation and restriction as it may impose tariff rates, import and export quotas, tonnage and wharfage dues, and other duties, or imposed within the framework of the National Development Program of the government. The President is granted standby or flexible tariff powers in the Tariff and Customs Code, conformably to the above provision. The reason for this delegation is the necessity, not to say expediency, of giving the chief executive the authority to act immediately on certain matters affecting the national economy, lest delay result in hardship to the people. It is recognized that the legislative process is much too cumbersome for the speedy solution of some economic problems, especially those relating to foreign trade. In Akbayan versus Aquino, the Supreme Court clarified that the subject of this constitutional provision is not the power to negotiate treaties and international agreements, but the power to fix tariffs rates, imports and export quotas, and other taxes, and accordingly should not be considered as a source of the power of the President to negotiate international trade agreements. Emergency powers. Section 23, paragraph 2. In times of war or other national emergency, the Congress may by law authorize the President for a limited period and subject to such restrictions as it may prescribe to exercise powers necessary and proper to carry out the declared national policy, unless sooner withdrawn by resolution of the Congress. Such powers shall cease upon its next adjournment. In times of war or other national emergency, it is not likely that a quorum can be convened in the Congress to enable it to do business. Assuming such quorum, there is still the divisive and delay inherent in the lawmaking process that may hamper effective solutions of the problem caused by the emergency. Such problems, needless to say, must be solved within the shortest possible time to prevent them from aggravating the difficulties of the nation. To this end, the Congress may authorize the President to exercise emergency powers. This authority may then be discharged by him with more dispatch and decisiveness that can be expected from the Congress itself dealing with the crisis. When emergency powers are delegated to the President, he becomes in effect a constitutional dictator. But in strict legal theory, there is no total abdication of legislative authority in his favor. The conferment itself is supposed to be subject to certain restrictions and requirements intended to make him only an agent rather than a replacement of the legislature. The conditions for the vesture of emergency powers in the President are the following. 1. There must be war or other national emergency. 2. The delegation must be for a limited period only. 3. The delegation must be subject to such restrictions as the Congress may prescribe. 4. The emergency powers must be exercised to carry out a national policy declared by the Congress. There cannot be any delegation of emergency powers in the absence of an emergency. Furthermore, the emergency powers are self-liquidating unless sooner withdrawn, or in the essence that they will automatically cease upon the end of the emergency that justified their delegation. Thus, CA number 671, which conferred emergency powers of the president following the outbreak of the Pacific War in 1941, authorized their exercise only during the existence of the emergency. Other national emergency may include rebellion, economic crisis, pestilence, or epidemic, typhoon, flood, or other similar catastrophe of nationwide proportions or effect. Conferment of emergency powers on president is not mandatory on the Congress. In the face of the worst crisis, the Congress may choose to hold on to its legislative powers and validly refuse to delegate it. Or should it decide to do so, limit its duration and terminate it even before the end of the emergency. The emergency does not automatically confer emergency powers on the president, according to Chief Justice Paras. Emergency itself cannot be and should not create power. By the same token, the mere continuance of the emergency does not necessarily continue the president's emergency powers if they have been granted to him for a shorter period. In every case, to prevent the delegation from being a total surrender of legislative authority, it must be subject to the restrictions to be prescribed by the Congress. The specific requirement of the Constitution is that the president may authorize to exercise powers necessary and proper only for the purpose of carrying out a national policy, declared not by him, but by the Congress. Any act of the president that is not in keeping with this national policy can be challenged as beyond the scope of his delegated authority. In the first emergency powers cases, the petitioners questioned the exercise by President Quirino of emergency powers previously vested in President Quezon and successively exercised by Presidents Osmeña and Rojas. At stake was the validity of certain executive orders promulgated by President Quirino, providing specifically for the appropriation of public funds in the operation of the national government and the conduct of the 1949 elections, the control of exports, and the regulation of the rentals of residential lots and buildings. In declaring such executive order invalid, the Supreme Court, through Justice Tuason, declared inter alia. Quote, Commonwealth Act number 671 does not in terms fix the duration of its effectiveness. The intention of the act has to be sought for in its nature, the object to be accomplished, the purpose to be subserved, and its relation to the Constitution. The consequences of the various in construction offered will also be resorted as to additional aid to interpretation. We test a rule by its results. And Article 6 of the Constitution provides that any law passed by virtue thereof should be for a limited period. Limited has been defined to mean restricted in duration, extent, or scope. The words limited period, as used in the Constitution, are beyond question, intended to mean restrictive in duration. Emergency, in order to justify the delegation of emergency power, must be temporary, or it cannot be said to be an emergency. It is to be presumed that Commonwealth Act number 671 was approved with this limitation in view. The opposite theory would make the law repugnant to the Constitution and is contrary to the principle that the legislature is deemed to have full knowledge of the constitutional scope of its powers. The assertion that new legislation is indeed to repeal the act would not be in harmony with the Constitution either. If a new and different law were necessary to terminate the delegation, the period for the delegation, it has been correctly pointed out, would be unlimited, indefinite, negative, and uncertain. That which was intended to meet a temporary emergency may become permanent law. For Congress might not enact the repeal, and even if it would, The repeal might not meet the approval of the president, and the Congress might not be able to override the veto. It is our considered opinion, and we so hold, that Commonwealth Act number 671 became inoperative when Congress met in regular session on May 25, 1948, and the Executive Order number 62, 192, 225, and 226 were issued without authority of law. In setting the first regular session of Congress instead of the first special session, which preceded it as the point of expiration of the Act, we think we are giving effect to the purpose and intention of the National Assembly in a special session. The Congress may consider general legislation or only such subjects as he, President, may designate. Section 9, Article 6 of the Constitution. In a regular session, the power of the Congress to legislate is not circumscribed except by the limitation imposed by the organic law. Despite this decision, President Corino continued exercising emergency powers, promulgating 2 executive orders appropriating public funds for public works and the relief of typhoon victims. These acts were challenged in the second emergency powers cases, where the additional circumstances appeared that the Congress had passed House Bill number 727, repealing all emergency power acts except that this measure had been vetoed by the president. On this point, the Supreme Court, through Chief Justice Paras, made the following pronouncement. Quote, although House Bill number 727 had been vetoed by the president and did not thereby become a regular statute, it may at least be considered as a concurrent resolution of the Congress formally declaring the termination of the emergency powers. To contend that the bill needed presidential acquiescence to produce effect would lead to the anomalous, if not absurd, situation that, while Congress might delegate its power by a simple majority, it might not be able to recall them except by 2/3 vote. In other words, it would be easier for Congress to delegate its powers than to take them back. This is not right and is not and ought not to be the law. Apparently, taking its cue from this ruling, the 1973 Constitution provides that the delegation of emergency powers to the president could be withdrawn by resolution. That part of the rule is understandable. But what is rather mystifying is why it was also provided that unless such emergency powers were sooner withdrawn by resolution, they would continue until the next adjournment of the legislature. What is more perplexing is why the Constitutional Commission perpetuated the error in the new charter. The next adjournment obviously refers to the session called after the adjournment of the first session, when the emergency powers were delegated. Hence, unless the delegation is sooner withdrawn, legislative power can be exercised concurrently by the President and the Congress during the second session and until its adjournment. This would run counter to the ruling in the first emergency power cases, that the emergency powers were terminated automatically the moment the Congress was able to reconvene in regular session and resume its legislative power. It would also permit rather than prevent the anomalous situation envisioned by Justice Tuason. Thus, quote, more anomalous than the exercise of legislative functions by the president when Congress is in the unobstructed exercise of its authority is the fact that there would be 2 legislative bodies operating over the same field, legislating concurrently and simultaneously, mutually nullifying each other's actions. Even if the emergency powers of the president, as suggested, be suspended while Congress was in session and be renewed after each adjournment, the anomaly would not be eliminated. Congress, by a 2/3 vote, could repeal executive orders promulgated by the president during congressional recess, and the president in turn could treat in the same manner between sessions of Congress, laws enacted by the latter. This is not a fantastic apprehension. In two instances, it materialized. In entire good faith and inspired only by the best in the interest of the country as they saw them, a former president promulgated an executive order regulating house rentals after he had vetoed a bill on the subject enacted by Congress. And the present chief executive issued an executive order on export control after Congress had refused to approve the measure. Section 17 of Article 7 of the Constitution additionally provides, in times of national emergency, when the public interest so requires, the state may, during the emergency and under reasonable terms prescribed by it, temporarily take over or direct the operation of any private-owned public utility or business affected with public interest. In David versus Arroyo, the Supreme Court declared that while the president alone can declare a state of national emergency, he may not invoke this provision to authorize him during the emergency to temporarily take over or direct the operation of any privately owned public utility or business affected with public interest without authority from Congress. It stressed that without legislation, he has no power to take over privately owned public utility or business affected with public interest. In short, the president has no absolute authority to exercise all the powers of the state under Section 17, Article 7 in the absence of an Emergency Powers Act passed by Congress. It should be noted that in the later case of Divina Gracia versus Consolidated Broadcasting System, Inc., the court, citing several laws, recognized that the president has been authorized by the Congress to exercise considerable infringements on the rights of the franchisees to operate their enterprises, citing as a corollary constitutional justification. Therefore, the provisions of Section 17, Article 7 of the Constitution. Number 3, delegation to the people. According to Cooley, the prevailing doctrine in the courts appears to be that, except in those cases whereby the Constitution the people have expressly reserved to themselves a power of decision, the function of legislation cannot be exercised by them, even to the extent of accepting or rejecting a law which has been framed for their consideration. The people have voluntarily surrendered that power when they adopted the Constitution. The government of the state is democratic, but it is a representative democracy. And in passing general laws, the people act only through their representatives in the legislature. Such reference of the law to the people at large for acceptance or rejection is plain surrender of the lawmaking process. But in People versus Vera, our Supreme Court observed that courts have also sustained the delegation of legislature power to the people at large. Although he was quick to add that some authorities maintain that this may not be done, a referendum is traditionally defined as a method of submitting an important legislative measure to a direct vote of the whole people. It differs from the plebiscite in that the questions submitted in the latter are intended to work more permanent changes in the political structure, like a proposal to amend the Constitution. According to Strong, the term plebiscite means literally decree of the people. The plebiscite is a device to obtain a direct popular vote on a matter of political importance, but chiefly in order to create some more or less permanent political conditions. In our jurisdiction, these terms are defined in Republic Act 6735, which implements Section 32 of Article 6 on initiatives on national and local legislation, and Section 2 of Article 17 on initiatives on the Constitution. Under said law, a referendum is the power of the electorate to approve or reject a legislation through an election called for the purpose, while plebiscite is the electoral process by which an initiative on the Constitution is approved or rejected by the people. I'm going to repeat that part. In our jurisdiction, these terms are defined in Republic Act 6735, which implements Section 32 of Article 6 on initiatives on national local legislation and Section 2 of Article 17 on initiatives on the Constitution. Under said law, a referendum is the power of the electorate to approve or reject a legislation through an election called for the purpose, while a plebiscite is the electoral process by which an initiative on the Constitution is approved or rejected by the people. 4. Delegation to local governments. Another accepted exception to the rule against delegation of legislative power is delegation to local governments. This traditional exception is based on the recognition that local legislatures are more knowledgeable than the national lawmaking body on matters of purely local concern and are therefore in a better position to enact the necessary and appropriate legislation thereon. Quote, it is a cardinal principle of our system of government that local affairs shall be managed by local authorities and general affairs by the central authority. And hence, while the rule is also fundamental that the power to make laws cannot be delegated, the creation of municipalities exercising local self-government has never been held to trench upon that rule. Such legislation is not regarded as a transfer of general legislative power, but rather as the grant of the authority to prescribe local regulations according to immemorial practice, subject, of course, to the interposition of the superior in cases of necessity. Accordingly, the power of eminent domain and under the General Welfare Clause, the police power have been expressly delegated by the legislature to the lawmaking bodies. The power of taxation is, however, derived by them directly from the Constitution, subject only to limitations that may be imposed by the Congress. Indeed, it was acknowledged in Bandanas versus Ochoa that, quote, municipal corporations are now commonly known as local governments. They are the bodies politic established by law, partly as agencies of the state to assist in the civil governance of the country. Their chief purpose has been to regulate and administer the local and internal affairs of the cities, municipalities, or districts. They are legal institutions formed by charters from the sovereign power, whereby the populations within community living within prescribed areas have formed themselves into bodies or districts. They are legal institutions formed by character from the sovereign power, whereby the populations within communities living within prescribed areas have formed themselves into bodies, politic and corporate, and assumed their corporate name with the right of continuous succession, and for the purposes and with the authority of subordinate self-government and improvement in the local administration of the affairs of the state. Municipal corporation, being mere creatures of the state, are subject to the will of Congress. Their creator, their continued existence, and the grant of their powers are dependent on the discretion of Congress. This is not to say, though, that said discretion of the Congress is unlimited, as further explained by the court. The 1987 Constitution limits Congress's control over the LGUs by ordaining in Section 25 of its Article 2 that the state shall ensure the autonomy of local governments, The autonomy of the LGUs, as thereby ensured, does not contemplate the fragmentation of the Philippines into a collection of mini states or the creation of imperium in imperio. The grant of autonomy simply means that Congress will allow the LGUs to perform certain functions and exercise certain powers in order not for them to overly dependent on the national government, subject to the limitations that the 1987 Constitution or Congress may impose. Local autonomy recognizes the wholeness of the Philippine society and its ethno-linguistic, cultural, and even religious diversities. The constitutional mandate to ensure local autonomy refers to decentralization in its broad or general sense. Decentralization has two forms in the Philippine setting, namely the decentralization of power and the decentralization of administration. The decentralization of power involves the abdication of political power in favor of the autonomous LGUs to grant them the freedom to chart their own destinies and to shape their futures with minimum intervention from the central government. This amounts to self-immolation because the autonomous LGUs thereby become accountable, not to the central authorities, but to their constituencies. On the other hand, the decentralization of administration occurs when the central government delegates administrative powers to the LGUs as the means of broadening the base of governmental powers and of making the LGUs more responsive and accountable in the process, and thereby ensure their fullest development as self-reliant communities and more effective partners in the pursuit of the goals of national development and social progress. This form of decentralization further relieves the central government of the burden managing local affairs so that it can concentrate on national concerns. Two groups of LGUs enjoy decentralization in distinct ways. The decentralization of power has been given to the regional units, namely Autonomous Region of Muslim Mindanao, or ARM, and the constitutionally mandated Cordillera Autonomous Region, CAR. The other groups of LGUs, i.e. provinces, cities, municipalities, and barangays, enjoy the decentralization of administration. The distinction can be reasonably understood. The provinces, cities, municipalities, and barangays are given decentralized administration to make governance at the local levels more directly responsive and effective. In turn, the economic, political, and social development of the smaller political units are expected to propel social and economic growth and development. In contrast, the regional autonomy of the ARM and the CAR aims to terminate groups with common traditions and shared social cultural characteristics to freely develop their way of life and heritage, to exercise their rights, and to be in charge of their own affairs through the establishment of a special governance regime for certain member communities who choose their own authorities from within themselves and exercise the jurisdictional authority legally accorded to them to decide their internal community affairs. It is to be underscored, however, that the decentralization of power in favor of the regional units is not unlimited, but involves only the powers enumerated by Section 20, Article 10 of the 1987 Constitution, and by the Acts of Congress 4, with various powers being devolved to the regional units. The grant and exercise of such powers should always be consistent with and limited by the 1987 Constitution and the national laws. In other words, the powers are guardedly, not absolutely, abdicated by the national government. 5. Delegation to administrative bodies. The reasons given earlier for the delegation of legislative power in general are particularly applicable to administrative bodies. with the proliferation of specialized activities and their attendant peculiar problems, the national legislature has found it more and more necessary to entrust to administrative agencies quasi legislative power or the power of subordinate legislation, as it is called. Thus, in Kalalang versus Williams, the court explained that with the growing complexity of modern life, the multiplication of the gestures of governmental regulation and the increased difficulty of administering the laws, the rigidity of the theory of separation of governmental powers has, to a large extent, been relaxed by permitting the delegation of greater powers by the legislative and vesting a larger amount of discretion in administrative and executive officials, not only in the execution of the laws, but also in the promulgation of certain rules and regulations calculated to promote public interest. The three powers of government, executive, legislative, and judicial, have been generally viewed as non delegable. However, in recognition of the exigencies that contemporary governance must address our local system, has recognized the validity of subordinate legislation. Indeed, according to Supreme Court, given the volume and variety of interaction in today's society, it is doubtful that if the legislature can promulgate laws that will deal adequately with and respond promptly to the more minutiae of everyday life. Hence, the need to delegate the administrative bodies, the principal agencies tasked to execute laws in their specialized field, the authority to promulgate rules and regulations to implement a given statute and effectuate its policies. With this power, administrative bodies may implement the broad policies laid down in a statute by filling in the details which the Congress may not have the opportunity or competence to provide. This is affected by their promulgation of what are known as supplementary regulations, such as the implementing rules inside or issued by the Department of Labor or the Labor Code. These regulations have the force and effect of law. Administrative agencies may also issue contingent regulations pursuant to a delegation of authority to determine some facts or state of things which the enforcement of a law depends. In other words, they are allowed to ascertain the existence of particular contingencies and, on the basis thereof, enforce or suspend In other words, they are allowed to ascertain the existence of particular contingencies and on the basis thereof enforce or suspend the operation of a law. Such contingent regulation also have the force and effect of law. A case in point of is Cruz versus Youngberg. The law involved here prohibited the entry into the country of foreign cattle, which had been determined by the Philippine legislature as the cause of a rinderpest epidemic that had killed many of the local livestock. The same law, however, authorized the Governor General to lift the prohibition with the consent of the presiding officers of the lawmaking body. If he should ascertain after a fact-finding investigation that there was no longer any threat or contagion from imported cattle. Administrative issuances may be classified into two: the legislative rule and the administrative rule. The former is in the matter of subordinate legislation designed to implement a primary legislation by providing the details thereof. On the other hand, the latter is designed to provide guidelines to the law, which the administrative agency is in charge of enforcing. When an administrative law is merely interpretative in nature, its applicability needs nothing further than its bare issuance, for it gives no real consequence more than what the law itself has already prescribed. When, on the other hand, the administrative rule goes beyond merely providing for the means that can facilitate or render least cumbersome the implementation of the law, but substantially increase the burden of those governed. It behooves the agency to accord, at least to those directly affected, a chance to be heard, and thereafter to be duly informed before the law issuance is given the force and the effect of law. For an administrative regulation to be valid, its promulgation must be authorized by the legislature. It must be within the scope of the authority given by the legislature. It must be promulgated in accordance and prescribed procedure. It must be reasonable. Quote, it is an elementary rule in administrative law that administrative rules and regulations enacted by administrative bodies to implement the law which they are entrusted to enforce have the force of law and are entitled to great weight and respect. However, these implementations of the law must not override, supplant, or modify the law, but must remain consistent with the law they intend to implement. It is only Congress which has the power to repeal or amend the law. Subordinate legislation from specialized administrative agencies must be germane to the objects and purposes of the law and in conformity with the standards prescribed by the law, to be held as a valid exercise of delegated legislative authority. The Administrative Code of 1987 further requires the filing of rules adopted by administrative agencies with the University of the Philippines Law Center, except our interpretative regulations and those merely internal in nature, which do not require filing with the UP Law Center for their enforceability. It should be pointed out that administrative bodies in their enforcement of laws may likewise be allowed to exercise delegated quasi-judicial power, which is known as the power of the administrative agency to determine questions of facts to which the legislative policy is to apply, in accordance with the standards laid down by the law itself, as it involves the exercise of discretion in determining the rights and liabilities of the parties. The proper exercise of quasi-judicial power requires the concurrence of two elements. One, jurisdiction which must be acquired by the administrative body, and two, the observance of the requirements of due process. That is the right to notice and hearing. It is the power, one, to hear and determine questions of facts to which legislative policy is to apply, and two, decide in accordance with the standards laid down by the law itself in enforcing the administering the law. A quasi-judicial agency is a government body not part of the judiciary or the legislative branch, which adjudicates disputes and creates rules which affect private parties' rights. It is created by an enabling statute, and thus its existence continues beyond the resolution of a dispute and is independent from the will of the parties. Its power are limited to those expressly granted or necessarily implied in the enabling law. Test of delegation. Assuming that the delegation of legislative power comes under any of the permissible exceptions, there is still the question of whether or not the delegation has been validly made to be valid. To be valid, the delegation itself must be circumscribed by legislative restrictions. not a roving commission that will give the delegate unlimited legislative authority. It must not be a delegation running riot and not canalized within banks that keep it from overflowing. Otherwise, the delegation is in legal effect an abdication of legislative authority. In total, surrender by the legislature of its prerogatives in favor of the delegate. According to our Supreme Court, the true distinction is between the delegation of power to make the law, which necessarily involves discretion as to what the law shall be, and conferring authority or discretion as to its execution, to be exercised under the pursuance of the law. The first cannot be done. To the latter, no valid objection can be made. Thus, the Supreme Court has declared that all that is required for the valid exercise of this power of subordinate legislation is that the regulation be germane to the objects and purposes of the law, and that the regulation be not in contradiction to, but in conformity with the standards and prescribed by the law. These requirements are denominated as the completeness test and the sufficient standard test. The completeness test. Ideally, the law must be complete in all its essential terms and conditions when it leaves the legislature, so that there will be nothing left for the delegate to do when it reaches him except to enforce it. A law is complete when it's set forth therein the policy to be executed, carried out, or implemented by the delegate. If there are gaps in the laws, that will prevent its enforcement unless they are first filled. The delegate will then have been given the opportunity to step into the shoes of the legislature and to exercise a discretion, essentially legislative, in order to repair the omissions. This is invalid delegation. Thus, in United States versus Ang Tang Ho, a law authorized the Governor General, whenever for any cause conditions arise resulting in extraordinary rise in the price of palay, rice, or corn, to issue and promulgate, with the consent of the Council of State, temporary rules and emergency measures for carrying out the purposes of this act. Pursuant to this authorization, he issued regulations fixing ceiling prices of the said cereals. The appellant, who was prosecuted for selling above the said ceiling prices, challenged the law on the ground that it constituted an invalid delegation of legislative power for failure to conform to the completeness test. The Supreme Court sustained his contention, declaring as follows: by its very terms, the promulgation of temporary rules and emergency measures is left to the discretion of the Governor General. The legislature does not undertake to specify or define under what condition or for what reasons the Governor General shall issue the proclamation, but says that it may be issued for any cause and leaves the question of what it may cost to the discretion of the Governor General. The legislature does not also define what is an extraordinary increase in the price of palay, rice, or other cereal. That is also left to the discretion of the Governor General. The law does not specify or define what such temporary and emergency measures shall remain in force and effect, or when they shall take effect. All of these are left to the sole judgment and discretion of the Governor General. The law is thus incomplete as a legislation. 2. The sufficient standard test. A delegation of legislative power should be made subject to a sufficient standard. A sufficient standard is intended to map out the boundaries of the delegate's authority by defining the legislative policy and indicating the circumstance under which it is to be pursued and affected. The purpose of the sufficient standard is to prevent a total transference of legislative power from the lawmaking body to the delegate, who is not allowed to step into the shoes of the legislature and exercise a power essentially legislative. According to the Supreme Court, a sufficient standard is one which defines Legislative policy marks its limits, maps out its boundaries, and specifies the public agency to apply it. It indicates the circumstances under which the legislative command is to be effective. Moreover, a law lays down a sufficient standard when it provides an adequate guidelines or limitations in the law to map out the boundaries of the delegate's authority and prevent the delegation from running riot. To be sufficient and standard must specify the limits of the delegate's authority, announce the legislative policy, and identify the conditions under which it is to be implemented. The sufficient standard is usually indicated in the law delegating legislative power. To illustrate, the Blue Sky Law required the National Treasurer to cancel certificates for the sale of speculative securities whenever necessary in public interest. The Supreme Court has considered the optimization of the revenue generation capability and collection of the Bureau of Internal Revenue and the Bureau of Customs as being infused with public interest. Under RA number 51, the President of the Philippines was authorized to reorganize government-owned or controlled corporations for the purpose of promoting simplicity, economy, and efficiency in their operations. CA number 548 empowered the Director of Public Works to promulgate traffic rules in the light of the public welfare. Other accepted standards are justice and equity, the sense and experience of man, and national security. But even if the law itself does not expressly pinpoint the standard, the courts will bend over backward to locate the same elsewhere in order to spare the statute, if it can, from unconstitutional infirmity. Thus, in Hirabayashi versus United States, the petitioner challenged a regulation establishing curfew hours for Nisis or American citizens of Japanese ancestry during World War II. One of his claims was that the rule was based on invalidly delegated legislative power, there being no sufficient standard mentioned in the pertinent law to limit the delegate's discretion. The U.S. Supreme Court held that there was a sufficient standard, to wit, the national security, and declared as follows. It is true that the Act does not in terms establish a particular standard to which orders of the military commander are to conform, but the executive order, the proclamation, and the statute are not to be read in isolation from each other. They were part of a single program and must be judged as such. The Act of March 21, 1942 was an adoption by Congress of the executive order and the proclamation. The proclamation themselves followed the standard authorized by the executive order, the necessity of protecting military resources in the designated areas against espionage and sabotage. In Deliana versus Alba, Chief Justice Fernando said, petitioners would characterize as an undue delegation of legislative power to the president the grant of authority to fix the compensation and the allowances of the justices and judges thereafter appointed. A more careful reading of the challenge Batas Pambansa Building 129 ought to have cautioned them against raising such an issue. The language of the statute is quite clear. The question provision read as follows. Intermediate appellate justices, regional trial judges, metropolitan trial judges, municipal trial judges, and municipal circuit trial judges shall receive such compensation and allowance as may be authorized by the President along the guidelines set forth in Letter of Implementation number 93, pursuant to Presidential Decree number 985, as amended by Presidential Decree number 1597. Chapter 4, Section 41 of BP Big 129, Batas Pambansa. The existence of a standard is thus clear, but it was different in People versus Vera. where our Supreme Court found the old Probation Act constitutional. Besides being violative of the Equal Protection Clause, the law was held to be an invalid delegation of legislative power for lack of sufficient standard. The Probation Act was not to be effective immediately. Its effectivity was made to depend upon an act to be done by the provincial boards of the provinces, that is, appropriating funds for the salary of a probation officer. If the provincial board makes the appropriation, the Probation Act is applicable in that province. If it does not make the appropriation, the law is not applicable therein. For purposes of the Probation Act, the provincial board may thus be regarded as administrative bodies endowed with power to determine when the act shall take place in their respective provinces. However, the law does not lay down any rule or standard or guide the provincial boards in the exercise of their discretionary power. What is granted to them is a roving commission, which enables the provincial boards to exercise arbitrary discretion. The applicability and application of the Probation Act are entirely placed in the hands of a provincial board with no standard or rule to guide them. This is a virtual surrender of legislative power to them. In Inat versus Intermediate Appellate Court, the court noted, we also mark on top of all this the questionable manner of the disposition of the confiscated property as prescribed in the question executive order. It is there authorized that the seized property shall be distributed to the charitable institutions and other similar institutions as the chairman of the National Meat Inspection Commission may see fit. In the case of cattle beef and to serving farmers through dispersal as the director of animal industry may see fit. In the case of carabaos, the phrase may see fit it an extreme, generous, and dangerous condition. If condition it is laden with perilous opportunities for partiality and abuse, and even corruption. One searches in vain for the usual standard, and the reasonable guidelines, or better still, the limitation that the set of officers must observe when they make their distribution. There is none. Their options are apparently boundless. Who shall be the fortunate beneficiaries of their generosity, and by what criteria shall they be chosen? Only the officer's name can supply the answer. They and they alone may choose the grantees as they see fit and in their own executive and exclusive discretion. Definitely, there is here a roving commission, a wide and sweeping authority that is not canalized within banks that keep it from overflowing. In short, a clearly profligate and therefore invalid delegation of legislative powers. The Pelaez case. The case of Emmanuel Pelaez versus Auditor General is worthy of special attention because of its discussion of the test of valid delegation of legislative power. At issue here was the validity of Section 68 of the revised Administrative Code, empowering the President of the Philippines to create, merge, divide, abolish, or otherwise alter the boundaries of municipal corporations. Pelaez contended inter alia that it was invalid delegation of legislative power. The government argued that it was not invoking the earlier case of Cardona versus Binongoan, where the power of the Governor General to transfer territory from one municipality to another was sustained. The Supreme Court upheld Pelaez. Significantly, it ruled that the completeness test and the sufficient standard test, which had thereto been applied alternatively, must be applied together or concurrent. Justice Roberto Concepcion, speaking for the court, declared, quote, although Congress may delegate to another branch the government the power to fill details in the execution, enforcement, or administration of a law, it is essential to forestall a violation of the principle of separation of powers that said law A, be complete in itself. It must set forth therein the policy to be executed, carried out, or implemented by the delegate. And B, to fix a standard, the limits of which sufficiently determinate or determinable to which the delegate must conform in the performance of its functions. Indeed, without a statutory declaration of policy, which is the essence of every law, and without the aforementioned standard, there would be no means to determine with reasonable certainty whether the delegate has acted within or beyond the scope of his authority. Hence, he could thereby arrogate upon himself the power not only to make the law, but also, and this is worse, to unmake it by adopting measures inconsistent with the end sought to be attained by the act of Congress, thus nullifying the principle of separation of powers and the system of checks and balances, and consequently undermining the very foundation of our republican system. Section 68 of the revised administrative code does not meet these well-settled requirements for a valid delegation of the power to fix the details in the enforcement of a law. It does not enunciate any policy to be carried out or implemented by the president. Neither does it give a standard sufficiently precise to avoid the evil effects above referred to. According to Bureau of Customs Employee Association versus Teves, the Supreme Court similarly ruled that two tests determine the validity of delegation of legislative power: the completeness test and the sufficient standard test. In finding that both tests were fully satisfied by RA number 9335, as evident from the aforementioned section 2, 4, and 7, completeness test and sufficiency standard test. On the other hand, the court in Belgica versus Executive Secretary considered the phrase "and for such other purposes as may be hereafter directed by the President under Section 8 of PD 910 as an undue delegation of legislative power insofar as to does not lay down a sufficient standard to adequately determine the limit to President's authority with respect to the purpose for which the Malampaya funds may be used," explaining that while it may be passed the completeness test, since the policy of energy development is clearly deducible from its text, the phrase should nonetheless be stricken down as unconstitutional as it lies independently, unfettered by any sufficient standard or delegating law. It is significant that, in the same case, the court also declared as unconstitutional Section 12 of PD 1869 as amended by PD 1993, which provided that the presidential social fund may be used to first finance the priority infrastructure development projects and second to finance the restoration of damaged or destroyed facilities due to calamities as may be directed and authorized by the Office of the President of the Philippines. It found that the law did not supply a definition of priority infrastructure development projects and hence leaves the president without any guidelines to construe the same, and ruled that, similar to the above assailed provision under Section 8 of PD 910, it lies independently unfeathered by any sufficient standard of the delegated law. Next chapter to follow, Chapter 8, the Legislative Department.